Hello, I'm Andy Agathangelo, the founder of the Transparency Task Force. Thank you very much indeed for wanting to watch this video. But just before it starts, here's a short but important message. It really does take a lot of time and money to produce our events, the videos, and all the campaigning work that we do. So if you're not already a subscription member, please do become one. That's really important. You'll find all the details you need through the link that you can see on the screen now. And if for any reason you're unable to become a subscription member, please at least make a donation. You'll see the link for our donations page coming up on the screen now. And just in case you need them, the links to both of those pages are in the video description. Thank you very much. Good afternoon. I'm Andy Agathangelo. I'm the founder of the Transparency Task. The Transparency Task Force is a certified social enterprise, and that's important. It means that it's to make an impact and not to make a profit. The impact we seek to create is all about the financial services industry. We believe the financial sector is profoundly important to the well-being of society, to economic stability, and to political stability. However, we know the financial services industry well enough to know that it has a very predisposition to misbehave given the chance to. And the view that we've come to over the last 7 years or so running the Transparency Task Force is that the financial regulatory framework in the UK and indeed many other countries is weak and ineffective. And as a consequence, the financial sector tends to misbehave far more than it ought to. Today, of course, is an event about Woodford. This is our second Woodford event. The last one was also very well attended. It resulted in the Woodford campaign group. It's quite remarkable to think that a scandal as big as Woodford took to the Transparency Task Force only just a few months ago to create the first really meaningful campaign led by victims themselves. And one of the things that the Woodford campaign group has done has been to a Facebook group, which you're all welcome to participate in if you are genuinely somebody that has lost money as a consequence of the Woodford scandal. The Facebook group, indeed the campaign group as a whole, is completely agnostic to any particular means for remedy and recompense. In other words, it is not tied to or in some way connected to any particular legal claim or strategy for getting compensation. I'm going to talk about the title because this is actually very, very important. As you can see, the title is Woodford, What's Next and Why Parliament Must Listen. The mistake to make in relation to Woodford is to think of it in terms of it being a standalone, isolated incident. It really is not. If you don't already know that, you will by the end of today's meeting. The Woodford scandal is one of a very long series of chronic and frankly catastrophic regulatory failure cases. And some of you may well have actually participated or watched the Panorama program that was aired a few weeks ago about the Blackmore bond scandal, another chronic and catastrophic regulatory failure case. And we, the Transparency Task Force, has concluded that the only real way to get these sorts of incidences happening far less frequently and far less severely is for there to be reforms through Parliament that would actually make the Financial Conduct Authority do its job of protecting consumers from harm far, far more effectively. That idea, the idea that the Financial Conduct has been failing to protect consumers from harm, is a recurring theme in the work of the Transparency Task Force. We didn't set out for that to be the case. When I created the Transparency Task Force back in 2015, I really did think that the regulatory framework was a huge part of the solution to the problem. But speaking very bluntly and candidly, that is not my view today. I genuinely believe that the way the financial sector is regulated, supervised, governed is a big part of the problem. And that is why we are seeing cases such as Woodford and Connaught and Blackmore Bond and LCNF and all the peer-to-peer cases and many, many, many others. I'm sure these things will come up during the course of today's event. Essentially, today's event is all about 4 key questions. These are the questions that really need to be dealt with. 1, what's happened? Number 2, who's to blame? That really is very, very important. These sorts of scandals don't just happen on their own. People get things wrong, either deliberately or otherwise. So who is to blame for what happened? Number 3, how can the victims get the justice and compensation they deserve? Number 4, what changes are needed to ensure that nothing like it ever happens again? We think they are very fair and very pertinent questions. We're going to be talking about a range of topics, including the 3 very significant reforms that could be carried out during the course of the Financial Services and Markets Bill. And my colleague Mark Bishop is going to be going into that topic in a fair amount of detail. I'm going to share my screen just to very, very quickly show you the running order of the speakers. In just about a minute or so, Neil Taylor will be speaking. He's been a Transparency Task Force member for some months. He's strong, he's a very capable gentleman. He's a leader of the Wellesley Investors Action Group, or rather one of the leaders of the Wellesley Investors Action Group. He's also a founder member of the Leadership Committee of the Woodford Campaign Group. After Neil, we'll be hearing from Cliff Waite, director at ShareSoc. ShareSoc have been running a Woodford-related campaign for some time. We then have Muriel Hodgson-Hill from Lee Day. Lee Day, of course, are one of the law firms conducting an action to try to get compensation and justice for the victims of Woodford. Mark Bishop's session is going to be particularly important, I would like to suggest. Please listen very attentively to what Mark sets out, in particular, the actions you could all engage with to genuinely help make a difference in terms of engaging parliamentarians and that kind of thing. And then we'll be hearing from Daniel at Harper, of course, as I'm sure you are aware, are also involved with the legal action, legal actions. I do hope that sets the scene very, very well. Some of you are brand new to the Transparency Task Force. If that's the case, we'll add you to our circulation list. We'll include you in our group called Scam Busters. We'll make you aware of other things you can engage with in due course. Those of you who are kind of seasoned Transparency Task Force members, great to see you and have you with us as well. We've got over 100 people today, which is a particularly good turnout. So thank you very much indeed for your attendance and participation. We're going to run the meeting in a reasonably informal, casual and relaxed way. The kind of all our events is please speak openly and plainly. This is a safe forum to have these kind of discussions. So don't be concerned if your views and opinions may be somewhat contrarian. What matters is bringing the truth to the surface, and that includes giving folks a chance to say what they really think. We're going to go to Neil Taylor now. Can I please invite you, first of all, folks, to please show your appreciation by applauding, because Neil's been putting a lot of work in the background in relation to the Facebook group and the Woodford Campaign Group and other things to try to help victims of scams and scandals, not just Woodford, not just Wellesley, to try to get compensation. So Neil, please introduce yourself and share with us the thoughts that you'd like to. Thank you.
Yeah, good morning, everyone. Can you all hear me?
We can, yeah.
Yeah, good. Just to let you know, I am on the Lead A Claimants Committee, one of 5 of us, so I have a vested interest in that avenue. As I said, Andy said that I'm the chair of the Wellesley Investor Action Group. There's about 600 people there are still not happy with the resolution of that, so we're pursuing that as well with the FCA in a big way, which has not been that successful, I must admit, so far. In terms of Woodford, I'm an investor in 2 funds. Just to give you a bit of personal thing, is I invested in the LF Woodford Equity Income Fund and also the Income Focus Fund for a small amount, which was set up about 90,000 put in. Losses are going to be about 38,000, I think, about 44% on the LF Equity Fund and about 30% on the Income Fund. So that's where I stand at the moment. So I've got a vested interest as well in pursuing whatever redress we can come up with or look at. As you know, the FCA have started their search for guilty parties, and it does appear that they're looking at everything since suspension. You know, that's my view of it. They're looking at everything from suspension, which from that point is about £900 million worth of losses. But you know, since inception, there's about £2.9 billion of losses. You know, if you go through it, it's huge number. So be interesting to see what happens here. Looking at the funds, there's about 97 million left in the fund to do a final distribution. I think everybody's aware of that, and I think that's planned to be done sometime this year. But if I compare that to my investment, it's I've got about 8% left of the capital in Hargreaves Lansdown. So if everybody else has got a similar number, that should be about £290 million. But the assets are only worth about 90, so you're only going to get no more than 30% back in the final distribution, I think. Probably a lot less, I guess. Looking at the Income Focus Fund, because that's quite important as well, there's about 154 million left in that, and I stayed in that for a little while longer, and I'm still in that with, I think Aberdeen are looking at that now, looking after it and reshaped it. Hopefully that'll be positive for the future. That fund is worth about 154 million today, down from 700 million at its peak. The interesting point I looked at is this 300,000 investors. We're not quite sure where they are, and interesting if everybody can answer that question. But we know there's 291,000 in Hargreaves, and that's been confirmed by Chris Hill, the CEO of Hargreaves. He said there's 133,000 investors when it was suspended, were direct investors, about £1 billion, 1.1 billion, and about 590 million, and there's 157,000 investors in the multi-manager funds. So there's quite a chunk of people who've got investments there. The rest we think are in various other groups, you know, Bell, Interactive Investors, places like that. Maybe even Fidelity International have got quite a few investors. Maybe pension funds, people put it through their SIPs and things like that, invested quite large amounts through their SIPs. But we don't know that for sure. What are the FCA doing? Well, everybody's been following the pursuit of Link Group because of the they're saying there's a shortfall against the cover that's within the UK company, because we're pursuing Link's Fund Solutions, as you know, and that deal's fallen through because of the company doesn't want to buy it and offered a lower price, so they won't accept it, and it's fallen through now. So, and I noticed their share price has gone down to 3 Australian dollars, which is about £1 billion lower than what it's worth in the offer. So that's quite a significant number, you know, and be interesting to know what happens going forward. Obviously, the legal options. Lee Day and Harkers Park are working closer together, and hopefully the GLO will bring them even closer in the near future. And there's at least over 20,000 clients there between the two parties. Hopefully that will grow, be significant. We do know that the claim with Lee Day and Harkers Park will be more significant. I think it will be wider and deeper. The other company that's interesting to know is about RGL, because we're not sure what they're doing. They haven't announced much yet, so I'll be keeping a tab on the tweets and see what's saying. But there's not a lot coming out of that at the moment, telling us where that's going. So it'd be interesting to hear anybody's views on that. If there's anybody involved with RGL at this time. It's quite interesting as well today to notice that Link were determined to pay, the Link Australian group was determined to pay their dividend to their shareholders, and they paid it, which was about the price of the fine that was imposed on them by the FCA. So there was some comment I noticed the other day that maybe they could have paid the fine rather than pay the dividend, but that's another story. So we'll see how this develops over the next few months, because I guess the FCA will have to take a legal action against LFS at the moment. I guess that's the route, but it'd be interesting to see how that pans out. I don't think there's much more for me to say. I can give you a copy of my notes if you want. Anybody wants them, I can post them up on the new site that's been operating. So anybody wants any notes, I've got lots of detail, but it's very difficult to give everybody all the information they need to know. But that's my assessment of it at the moment. So that's me finished at the moment.
Thank you very much indeed, Neil. Thank you. Okay, we're making good progress, which is excellent. If anybody wants to raise any points or ask any questions, please just raise your hand. Do that either digitally or literally, and then at the appropriate time we'll bring you into the conversation. I have put into the chat the link to the new Facebook group that the Woodford campaign group has created. You should find the process of joining it quite straightforward, and I do confirm that it is completely free of charge to join if you are somebody that has lost out as a consequence of the Woodford scandal. It's got well over 100 members already, but of course, if you haven't yet joined it, it probably makes sense for you to do so. We had somebody asking what a GLO is, and Muriel replied very promptly, a group litigation order, and Muriel, perhaps others are going to elaborate on that when we get to the session. Okay, let's now please invite Cliff Waite to speak. Thank you very much indeed, Neil, for what you've covered off. Cliff, over to you, please. I think you're with us. Please take yourself off mute and dive in. Thank you very much. If for some reason Cliff's not with us, we'll go straight on to our next speaker, who is Muriel, which looks like that might be the case. Yep, it is the case. So, Muriel, could you please pick up from there? Thank you very much indeed. Thank you.
Yes, of course. Hi, everyone. I'm just going to try sharing my screen. Hopefully, does that work? And can you all now see a slide with a piggy bank?
A smashed up piggy bank. What a very appropriate image. Yes, indeed.
Yeah, exactly. Okay, perfect. Yeah, hi, I'm Muriel. I'm a solicitor in the team at Lee Day, and I'm one of the people working on the claim that we're bringing on behalf of investors in the Woodford Equity Income Fund. And in the next 10 minutes or so, I'm going to tell you a bit about the claim that we're bringing. And I appreciate for some of you who've been to talks that I've spoken at before, there may be a little bit of repetition here, but I will also give an update about where we've got to and some of the important work that remains to do, and also talk about how the developments with the FCA kind of impact on the litigation. And I'm conscious also that my colleague at Harkers Park, Dan, is speaking in a bit, so I'll leave him to go into a bit more detail about the FCA stuff. So, so first of all, a bit about Lee Day. We are a Times Top 100 law firm, and we're one of the UK's leading group action specialists. We currently represent over 13,000 individuals who invested in the Woodford Equity Income Fund, which makes us the largest single group of, means that we represent the largest single group of investors in the fund. And we think this is really important work that we're doing to seek compensation for investors. And we're really proud to be representing the thousands of investors who lost out through no fault of their own, through the failings that happen with this fund. And we're working hard to secure justice. We're also working with a excellent team of barristers. There we go. Derek Dale Casey and Teniola Onabanjo, who are both experienced in commercial disputes and financial services disputes. So we're very lucky to be working with them. Before I go on to the detail of what the claim is about and where we've got to, I just wanted to cover how the costs of it's what we call an opt-in claim, which means that you sign up to the claim and only people who sign up are part of it. So I wanted to touch on and explain a bit about the terms that people sign up to if they choose to instruct Lead Day, just to be completely transparent about how it works. So litigation is a very expensive thing to do. Unfortunately, litigation on this scale is very expensive. There's the costs of lawyers, barristers, experts, insurance, and we need all of that in order to ensure that the claims have the best prospects of success. And the way that we do that is we work with a commercial litigation funder who pays all of the upfront costs of the litigation. And then if the claims are successful, then there are some success fees for the lawyers involved and also for the funder. And the way that is paid is as a deduction from compensation that claimants receive as part of the litigation. And with Lead Day, that deduction is capped at 30% of any compensation you receive. So the first thing just to say from that is we do feel that the fact that we have a commercial litigation funder backing us, that is a strong demonstration of confidence in the claim that we're bringing. And I should just say, Harkers Parker's in the same position on that. They also have funding. So we've got a really strong backing from the kind of commercial world to go forward with this litigation. But because we've got that funding, it means we're able to offer to act on a no-win, no-fee basis where claimants only pay if the litigation is successful. If you do want to find out any more about Lead Day's terms, you can have a look at our website. So I won't spend any more time on that and move on to the more interesting bit of what the claim is about and what we're trying to do. So Lead Day is bringing a claim on behalf of people who invested directly in the Woodford Equity Income Fund. So it doesn't include, unfortunately, people who were invested via multi-manager funds. The claim is against Link Fund Solutions, which is the authorised corporate director of the fund. And they, as the authorised corporate director, were responsible for ensuring that the fund was managed in accordance with the fund's prospectus and the rules applicable for the fund, which are set by the Financial Conduct Authority. And I'll explain a bit more what the allegations are, but just to focus on what I'm sure is really key for anyone who's thinking about what their options are. Through the litigation, we will be claiming compensation, which aims to put investors in the position they would have been in if the fund had been properly managed. So to give a hypothetical example of what that might look like, say, for instance, you invested £10,000 in the fund and say you've received back £6,000 through the distribution so far, you have effectively made a capital loss of £4,000, but there's also the profit that you expected to make when you invested your savings in this fund. So what we're doing is to look at the position that people are currently in, and then the position we say they should have been in. So they should have been earning profit on their investment, and we will look to put you in that position of having profit. So it's to claim more than just the amount that the shortfall that you've got from your investment. And how much that will be, exactly how much that will be the subject of expert evidence in due course. And we expect it will be hard fought in the litigation, and Link won't want to pay out, but we will push to get the best compensation that we can for individuals. So next, a bit of a recap on where we've got to and what we've achieved so far. So there have been extensive, what we call pre-action correspondence, where we've set out the allegations to Link, and they have come back to robustly deny that they did anything wrong. So where that's left us is we've issued claims at court for a large cohort of our clients. And then we've been speaking to the other law firms, which are acting for claimants in this claim, and in particular working very closely with Harcus Parker. And we have together applied for something called a group litigation order, which will enable us to essentially run the claims together. So we think this is a really positive step. It means we can pull together all of the claimants pulling in the same direction, and working hard to get Link on the hook for the losses that they've caused to investors. And what's coming up next is our application for a group litigation order has been listed by the court. It's been scheduled for December 2022. And then so we have that hearing towards the end of the year, and then we'll get some decisions from the court on procedural matters. So things like deadlines going forward in the claim, how we manage the claim, and costs management. So it's a really key stage for us in enabling us to push forward. I've put a bit more detail on the slide here. Sorry, on the next slide. Just get to it. Here we go. About what we're asking for. So yeah, I've touched on a bit of this already, but one of the other key things that I haven't mentioned is that this procedure will enable us to do costs sharing between the claimants. So we will essentially be limiting the amount of costs that each individual is liable for, sort of proportionate to their investment and to their stake in the litigation. But also I should emphasize that that is in any event covered by the insurance that Lead Day and Harcus Parker have. We have insurance to protect our clients. So we're at a good stage now with this group application or group litigation order application sort of on foot to press ahead. And as part of our application, we've also filed something called the generic particulars of claim. And this is a document which sets out all of the common facts and allegations that we make on behalf of the claimants. And it's a really key document. It's a key stage in the litigation because as I say, we've set out what exactly we say Link did wrong, and they've now got to answer those allegations that we put to them. And I don't propose to go over what we say in that document in too much detail. Many of you will be painfully aware of what happened with the fund, but I did just want to pull out one sort of key aspect of the document, which is that one way that we've approached this is to look at the investment objective of the fund, which was to provide a reasonable level of income together with capital growth, which would be achieved by investing primarily in UK listed companies. So we've looked at that objective and what Link said the fund would do, and then we've looked at what happened. And over time, as I'm sure many of you will have seen in the press reporting, and it's been widely covered, the fund drifted increasingly into small startup early stage companies, increasingly invested in unlisted assets. And these companies, their success or failure was very difficult to predict with confidence. It wasn't companies which were likely to pay dividends in the short term. And as a result, the fund became overly invested in illiquid, speculative, hard to value stocks. It had an inappropriate overall investment strategy, and it meant that there was an increasing risk of overvaluation of assets in the fund. So those are the central allegations that we are making against the defendant. And I'm sure that the key question for everyone who's thinking about, okay, well, what happens next? What's the timing, and when could I get some compensation? I've tried to put a bit of an indication on the slide of the stages that remain in a litigation. And I should emphasize that every litigation is different, and this all depends on what the court orders, what the parties do, how Link responds. And I can circulate these slides afterwards if anybody wants to have a closer look. But essentially, we have our hearing, we have our procedural hearing in December, and then the parties have to set out their legal position, and those documents have to be filed at court. The court will set a deadline for signing up to the litigation, and then once we've had everyone's arguments in writing, there might be some further case management from the court. And if we get this far, if Link doesn't come to the table with for settlement discussions, which of course we very much hope they will do, and we hope we'll be able to reach a swift resolution, we will, the remaining stages in the litigation, if we have to go through them, are disclosure of relevant documents, when we would be looking to get any kind of interesting documents on the Link side about how they were managing the fund, anything which supports our case. Witness evidence, so we'd be looking to get witness statements and witness evidence from key individuals at Link, get them to explain what they were doing. Expert reports, when we would have experts explaining and going into the detail of what the actual losses that individuals have suffered are. And then if we go all this way, and if it doesn't settle, a trial to deal with the issues once and for all. And in terms of timing, if we have to go all that way, it is unlikely that we will have a trial before 2024. So just to give you some kind of indication of the scale of this and what's involved. But as I say, we hope to press on much more quickly via settlement and negotiations. And then the last thing that I wanted to mention, and I don't want to say too much because I don't want to give any spoilers for anything that Dan is going to say, but I'm very conscious that in the last 2 weeks, the Financial Conduct Authority has provided an update on its investigation. So following the suspension of the fund, the FCA did launch an investigation, and it's taken them over 3 years to really give much of a significant update, but something has finally come. And they've indicated on a provisional basis that they think Link did fail in its management of the fund. So that's really significant because they've reached very similar conclusions to what we have following our investigations, that there were problems with the fund and its liquidity, and that Link did fail in that. And then they've proposed possible sanctions in terms of a penalty of 50 million and also a potential restitution payment of 306 million. And we've considered this in the context of the litigation to think, well, what does this mean for the claims we're bringing, and how does this fit with everything? And in terms of the amount of redress, what's really important to remember is that there were hundreds of thousands of investors in this fund. And as Neil has mentioned, the losses sustained were monumental. And our assessment, Liday's assessment, is that we don't think 306 million would be enough to compensate all investors, all consumers. But what I should also say is that it is very uncertain. The FCA's sort of indication is provisional. We think they're probably in discussions with Link about what to do. And this diagram that I've got on the slide, I hope sort of, as you can see, it's a very complicated process. In terms of where we are at the moment, I don't know if you can see where it says preliminary findings on the sort of first rung and options available. So that's about where the FCA has got to. They've reached a preliminary finding and they're exploring with Link the options available. And that could result in the case being closed. But also it could, if Link doesn't accept the FCA's findings, which every indication that it's made publicly is that it's not going to, it's indicated that it doesn't agree with the FCA. What would happen next is that the FCA submits its sort of what it wants to do to a regulatory decisions committee. So then you're coming back over to the stage on the left of my slide, and you go through a whole formal procedure for Link to challenge the FCA's initial decision. If that challenge is unsuccessful, then Link has a further right of appeal. And you've got this whole process. If Link sort of challenges all the way and isn't successful in that challenge and has to go through to a second level of appeal, we're looking at least a few years, several years, for a final resolution and any clarity on whether there's going to be a scheme. So where that leaves us for the litigation is, unfortunately, not much the wiser. We know that the FCA considers Link did do something wrong, but there's not any certainty about any kind of compensation coming from the FCA route at the moment. So essentially, we are pressing on. We are working hard to try and get compensation for investors as quickly as possible, but also making sure that it's adequate compensation to compensate people for the losses they have suffered. So that is the kind of Liday take on where we've got to on following the FCA's investigation. And that's everything I wanted to say, and hopefully I can just get, there we go. There's the Liday website about the claim if anybody wants to have a look. There's some FAQs on there, and hopefully some news articles and blogs, and hopefully some helpful information. And if anyone has any questions, please do send us an email or post in the chat, and I'll try and pick that up. Thank you very much.
Meryl, thank you very much indeed. I'm sure everybody's going to want to join me in showing our appreciation for your session. Thank you very much indeed, Meryl. That was excellent, very clear, very succinct as was last time. Excellent. We would love to circulate your slides, Meryl, so please do get those across to Chelsea. We'll make sure that they get included in the post events or circulation pack, as it were. Meryl, there are lots of questions for you in the chat. I propose we do this. We'll go to Mark Bishop now. That will give you a time to get your head around those questions and prepare answers for them after Mark's session. So we'll go to Mark Bishop, then we'll be jumping back to Meryl for her response to all of those questions that have been put into the chat, and then we'll go to Daniel after that, and then we'll be opening up for general Q&A afterwards. So Meryl, thank you again, once again. Mr. Mark Bishop, thank you, Mark, over to you. For those of you that don't know, Mark is very much my right-hand man in terms of running the Transparency Task Force. He makes a huge contribution to the cause, and as you're about to see, he has a remarkably deep insight into many of these issues. I'm sure Mark's going to be covering some points that some of you have never even thought of. It should be a very interesting session. Tune in. It's probably going to be quite complicated in places, but do tune right in, because there's going to be real nuggets of thought leadership in there, I know. Thank you very much indeed, Mark. Over to you. Cheers.
Okay, well, thank you very much indeed, Andy, for that very generous introduction. I'm going to do what I can to make this, although there's a lot of information in it, as accessible as possible. So I'm going to try and dial down the jargon, and hopefully everybody will follow. So I'm going to share screen first of all. Okay, so here's my presentation. So Andy said that there are 4 big questions, and those are: what happened and how much was lost? Who's to blame? The implications are, maybe we look at the obvious suspects and the real culprits. How might the victims get redress? And I will stress here, unlike Muriel, I'm not a lawyer. So everything I say here is only opinion, it's not legal advice. What changes are needed to ensure that nothing like this ever happens again. And for reasons that will become clear, I've kind of combined those last 2 sections. You'll see why in a little bit. So the first is how much is lost. Well, the Equity Income Fund alone had £3.7 billion in it when the fund was suspended, and there have been a number of losses on the realisations and a lot of time taken to get the money back, perhaps 4 years or more to fully realise the investments. But the other point that I think is often missed is that before it was suspended, there'd been a fall of almost 50% since the peak. So there are a lot of people who left during the life of the fund nursing losses when they would have had gains if they'd invested in a tracker or most other equity income funds. And therefore, those people who are in at the end are not the only victims. There was also, of course, the Woodford Patient Capital Trust. That was the listed investment trust that was really investing mostly in kind of moonshots. There was not a style drift with that. They expected to get moonshots, and they did, but a number of things went wrong with the governance of it. Some very crazy decisions were made. And there was Woodford's Income Focus Fund as well. The fund also appears in some other collective funds of funds, most notably from Woodford. It's also not just about capital. There was a loss of income and of opportunity, the growth versus sector peers, and of liquidity. Now, my personal guess is that the total losses really are north of £5 billion, but I fully accept that much of this may not be litigable, and there is a question mark about how much could be recovered via the various compensation routes that are available by statute. So I'm now going to just quickly go through the who's to blame, the obvious suspects. Woodford Investment Management, of course. They engaged in what's euphemistically known as a style drift. They were supposed to be running, a big, fairly low risk equity income fund, but in fact, a significant proportion of the money was invested in cash consumptive early stage businesses. There was a significant liquidity mismatch because these things were not kind of readily saleable. And this is particularly made worse by the fact there was an open-ended structure. So when people started redeeming their money, it was the big listed stuff that they had to sell, not the moonshots, and therefore the problem became worse over time. There was a significant lack of governance and sensible constraints. For example, did you know that Woodford Investment Management actually had no non-executive directors? There were never any directors of that firm other than the managing director and the investment director. There are many significant problems with compliance. There are breaches of liquidity and gearing rules. There were a number of connected party transactions. The fund invested in a number of businesses associated with a guy called Peter Dubens, who is a friend of Neil Woodford, and provided him with a number of valuable services, not least the use of offices in Mayfair when he was getting the business set up. There were a number of investments into all kinds of perhaps fairly dodgy businesses, listed by a guy called Anton Bilton, who is also an associate of Woodford. There were a number of trades involving directors and shadow directors of the entities. By shadow directors, I mean people who are not registered as a company house of directors, but are regarded as directors in terms of their powers or by the FCA. And then, of course, there was the big shareholding in Capita from the very outset, as notifiable shareholding. And Capita, of course, owned previously the authorised corporate director we now know as Link. And there is an unusual kind of quirk of the financial arrangement between the fund manager and Capita / Link, which is that the fees being charged by the ACD were, I think I'm right in saying, consistently below £100,000 a year, and it's been speculated that that is actually probably at or below the cost of providing the professional indemnity insurance in association with this activity, never mind the labour costs associated with it. So I can't actually say that, you know, Woody got a deal from Capita in return for being a supportive shareholder, but some people might speculate that's what happened. There was, of course, also the asset swap between the Equity Income Fund and the Patient Capital Trust. The Patient Capital Trust bought a load of the rubbish kind of shareholdings that were in the Equity Income Fund, in return for which the Equity Income Fund bought a shareholding in the Patient Capital Trust. It did so at the net asset value, the propriety of which you could perhaps question, rather than at the market price, which is about 12.5% lower. And if the fund manager had decided that the best way to deal with holding early stage businesses, if indeed it was appropriate to hold them, was to do so via an investment trust, then it would have been better surely to have invested in several investment trusts rather than one, and to have chosen ones that were really high performing instead of the Patient Capital Trust that was performing very badly. There's also Capita Financial Managers, which is now Link Fund Solutions. They had a duty, and I think it might actually be a fiduciary duty, to provide or to preserve the best interests of the investors in the Equity Income Fund. They clearly failed to restrain Woodford from doing a number of transactions that were not in clients' interests. And they also failed to replace the asset manager, which is a power that they had throughout this period. Hargreaves Lansdown, well, its main flaw was putting the fund on the best buy list, and particularly for keeping it on that list long after it became clear that there were problems, and indeed after its own multi-manager fund sold out its holding in the Equity Income Fund. Finally, there is Northern Trust Global Services PLC, which was the depository. I stress I haven't actually read the contract in relation to these people, but I understand that it was responsible for valuations and overseeing the authorised corporate director. Now, who's really to blame? And I have to say, I do think it's the Financial Services / Conduct Authority. And here is a list of the kind of charge sheet, if you like. It failed to sanction Neil Woodford for what we again will euphemistically call a style drift at Invesco. It's been suggested that some of the consumer funds were investing in derivatives, which was very high risk and totally inappropriate to the mandates that they had. He got away with it. Only the firm was fined. The innocent shareholders had to pay the bill. When Woodford left Invesco, the FCA actively accelerated the authorisation process of Woodford Investment Management to help him. It authorised Craig Newman to be the managing director of Woodford Investment Management, despite the fact that Invesco terminated him for cause for gross misconduct. It's alleged that he effectively stole client data. Now, that's a very serious allegation, not been through a court, but he was kicked out and he didn't, as I understand it, successfully challenge his dismissal. And I believe that the FCA's supervision rules would say that when somebody who's left a business under those circumstances wants to be reauthorised, there should be an extensive investigation. I doubt very much that happened while they were accelerating the authorisation of Woodford Investment Management. Also, a really bizarre thing happened. The FCA authorised a number of people to be non-executive directors of Woodford Investment Management. I think it's CF3 designation from memory on their register. You can find them there now. If you go to Companies House, you'll find that those people never actually became the non-executive directors of the firm. They were never directors of the firm. Now, why is it that they might have been reluctant to have the kind of legal responsibilities and liabilities that go with being a director? I wonder, why did the regulator not spot this? They were also horrifically conflicted because of investments made by the fund rather, in firms that they were associated with. And the same applies to the directors of the Woodford Patient Capital Trust. You know, they were either investee company directors, or they were people who directed investment funds that were co-investors alongside the Woodford Patient Capital Trust. The FCA failed to identify, prevent or penalise connected party transactions, which I've listed. It failed to protect consumers, this is a really important point, from capita financial managers stroke linked fund solutions. If you go onto the FCA register now, you will see various notices, final notices against that firm, but you'll see that its permissions are intact. It has never been fined by the FCA for the matters I'm about to describe. So the first is Arch Crew, a collective investment scheme in which there was kind of wrongful valuation of the assets, and there was arguably connected party transactions and other wrongdoing going on. Sound familiar? The Connaught Income Fund Series 1, I was an investor in this. It's what brought me into financial services campaigning. Here, effectively, a bunch of wide boys went to Capita and got them to become the operator and promoter of their product with zero due diligence, literally zero due diligence. They've omitted it. And they then kind of took £106 million of investors' money. Again, no sanction for that. Bizarrely, the FCA actually recommended or even required Woodford Investment Management to use this firm as its authorised corporate director. Heaven only knows why. Then another remarkable thing, after Connaught blew up, the FCA put together a team to supposedly investigate it. It was from the complex events team. And a member of that team, Chris Martin, who therefore was a person who actively investigated Connaught and knew about the problems back as far as 2012, subsequently became Woodford Investment Management's compliance manager. What are the odds of that happening purely by chance? Finally, the FCA routinely allows firms to breach what's called the threshold conditions. These are that a firm must show to get authorised and to remain authorised that it has a sufficiently strong balance sheet or sufficient professional indemnity cover to meet the type of claims that it might meet as a result of the type of work that it does. Now, I cannot prove at this point that Woodford Investment Management or Linked Fund Solutions or Northern, whoever they're called, Northern Trust, any of those people do have insufficient means to meet the claims that may be brought against them, but I wouldn't mind betting that's what turns out to be the case. So I'm going to talk very briefly about litigation, not as an expert, because I'm not a lawyer, but I'm just going to say as a layperson, here are some areas where I think that there could be some challenges. So the first is Woodford Investment Management. The enforcement investigation is ongoing, and in theory, it could lead to redress. One of the challenges is that the company actually has a negative net worth. Its liabilities exceed the value of its assets. It's not trading, so it has no kind of enterprise value, no intangible value. There is unknown professional indemnity cover. My guess is it will be in the low to mid single digit of millions of pounds. You know, I'd be amazed if they had even £10 million worth of cover, and I wouldn't mind betting if they will burn through much of that in legal costs alone. So to put money, they've got no money. The next is Link Fund Solutions and indeed the group. As we've heard, the FCA made the sale to a Canadian private equity-backed firm conditional on a £306 million retention, but it authorised the sale of 6 other subsidiaries. It looks as though the sale of all of them has fallen through. This is obviously a problem because it means that the group is not receiving, the shareholders of the group are not receiving some cash that could be made available for redress. The net asset value of Link Fund Solutions at the last balance sheet date was around £50 million, but it's facing an FCA fine of £50 million. That could be reduced if there was early payment, but at the moment it looks like Link is minded to contest the fine. The pre-tax profit of this subsidiary is between £4 and £7 million a year, so it does have an intangible value, but that value is far less than £306 million. From the point of view of the parent, given that permission has already been given for the sale of the subsidiaries, there is no reason why it wouldn't just let this one subsidiary go under. There may be some professional indemnity cover, though again, it may also have been allowed to self-insure for some of the risk. That's a euphemism that basically means that there are undertakings from other parts of the group, but we can't be sure of that. I don't know whether the lawyers have looked into this. It's also very interesting to look at the wording of the FCA's announcement that was made just a couple of weeks ago about this intended retention. They said, this figure reflects the FCA's view of LFS's failings in managing the liquidity of the Woodford Equity Income Fund. It doesn't mention any other product than the Equity Income Fund. It doesn't mention any sin other than managing the liquidity. It doesn't reflect any amount which may be owed to anyone else, including members of the fund, as a result of potential wrongdoings by other parties. That's significant. FCA determined redress is based on misconduct, not losses caused. That's an interesting interpretation of the law as I understand it, but I stress I'm not a lawyer, by fluctuations in the value of the price of investments. So also next there is Northern Trust Global Holdings PLC. Bizarrely, that entity no longer exists on Companies House. So I don't know whether it was some other part of Northern Trust that performed the function, if it was changed at some point, but it looks as though that could be a slippery one. And finally, there's Hargreaves Lansdown. Well, the good news is its market cap is £4 billion, so there is some value there. But only a minority of the investors were affected. And I think the case is probably fairly speculative in the sense that, you know, maybe at the time the people invested, it was on the best buy list for the best of reasons. And the failing was perhaps one of failing to notify them about concerns more than the kind of initial investment. But who knows, it's the law. Next thing is other options for redress. And this is probably, I think, more important. I think this is where the money will come from, or most of it. The first is the Financial Ombudsman Service. You'll recall, or you'll be aware for most people, that this is, if you like, a dispute resolution service created by statute, whose job is to deal with complaints that consumers have about authorised firms after the consumer has gone to the firm and tried to resolve the matter without success. The next is the Financial Services Compensation Scheme. This is a scheme funded by a levy on authorised firms that pays out to consumers in situations in which authorised businesses have gone into a financial default and are unable to meet such liabilities. So the FOS position is that it will suspend complaints until an FCA enforcement investigation concludes. So personally, my view is there's nothing to be gained from complaining to the FOS right now. If you wait, more information will become available to you, or it might do, so you might be able to submit a better complaint. Whereas if you submit one now, it'll just sit on the shelf until the whole thing's finished anyway. The next thing is the FSCS. Its role mostly is to stand behind awards that have been made by the Financial Ombudsman Service. It doesn't always do this, but it usually does. The second kind of possibility or role it has is to stand behind FCA restitution orders or Section 404 redress schemes. I would be very surprised if it didn't stand behind such a thing. There is also a question mark about whether it would stand behind an award of a competent court. I don't know whether that will happen. I'm not aware of any case law going either way, but I stress I'm not a lawyer and I would certainly appreciate the lawyer's view on these matters. Also, you should be aware that the limit of the Financial Services Compensation Scheme is £85,000 and it only covers qualifying investors. There is also a question mark about whether what might be known as double dipping would be allowed. So if you can get some money out of a litigation or out of a claim against, I don't know, Hargreaves Lansdown, do you then get some money out of the FOS, no, the FSCS, in respect of a claim against Woodford Investment Management or Linked Fund Solutions? I don't know. I think that overall, with litigation being on foot, clearly the FCA close to an enforcement action, and there also being the possibility of complaints to the FOS, dialogue with the three Fs as they're known, the FCA, the Financial Ombudsman Service and the FSCS, is needed fairly urgently. Next is the Financial Conduct Authority. It's relatively easy to demonstrate responsibility. This is a regulated product. All parts of it were within the FCA's regulatory perimeter, and there was clearly repeated cases of regulatory failure. However, getting money out of the FCA is much harder. It is broadly exempt from civil liability, barring two carve-outs, human rights breach and bad faith. So far, I'm not aware of any success under either of those heads, nor am I aware of anybody attempting to litigate in respect of Woodford under these heads. There is a complaint scheme that you can use as well. However, unfortunately, politicians made the mistake, in my view, of allowing the regulators to write rules of their own complaint scheme. And as a result, and there's a quote here from the actual Complaints Commissioner who deals with these complaints, ex gratia compensation payments due to regulatory failures on the part of the FCA will in practice never be available to complainants. So you can prove that they erred, but getting money out of them will be hard. Then there is government. Well, actually, you're probably aware of the London Capital and Finance case, LCF. In that situation, the Treasury paid partial redress to the victims. They made it very clear at the time that it was a one-off event, and the amounts of money involved in this case are at least 10 times larger and probably more like 50 times larger. I think it's going to be a struggle, particularly given the state of the country's finances. An independent review might help a little bit to make the moral case for it, but the FCA will resist such a thing happening until all its enforcement work concludes. And if you call for a review now, you can bet your bottom dollar their enforcement work is going to take a very long time, because they really do not want an independent review. And the other thing to stress is, even if you've got an agreement to have an independent review, it's not a silver bullet. The FCA and the Treasury hold all the strings because they can set all the parameters. And this case could potentially spell the FCA's downfall. So they will become very resistant. And if it happens, it won't necessarily give you the result you want. So this is why I kind of bring together the last two parts of the presentation, which is how you can get redress for yourselves and also how you can do the right thing for society. Thankfully, I do not believe that there is a conflict of interest between those two things in this happy occasion. Fate is on your side, and serially so. And the reason is that there is compelling proof that there is a need to upweight consumer rights in financial services. Now, the first is that many of you probably saw last month in August, an edition of Panorama was broadcast called the £1 billion savings scandal. And what it showed is that investors in a particular product, it was called Blackmore Bond, were not protected by the FCA. The FCA had been tipped off by somebody who literally had the office next door to the scammers and could hear them selling this rubbish product. And it happened that the people who were in the room next door and hearing all this going on, they were not your average Joes. They were ex-city traders who provide litigation support in complex financial services cases. So they knew that the thing was a scam. They knew what regulations were being breached. They were not idiots. So they contacted the FCA and said, this is going on. Would you like to come into our office, posing as members of our staff? And you can literally listen to this stuff and you can record it and you can get these people banged to rights. The FCA said, actually, we'd rather not bother. Thank you very much indeed. Same thing a year later when approached again. No, thank you. We're not interested. So that is a really egregious case of regulatory failure. And there's been a whole hour of Panorama absolutely damning about it. The next is we have a new Prime Minister. Whether you love or hate this Prime Minister, she actually has spotted that there's a problem with the FCA. She's got a proposed solution we don't agree with, which is to merge it with a couple of other regulators, but at least she knows there's a problem. That's the first time we've seen that in a long while. The third thing is we at Transparency Task Force provide the secretariat to an all-party parliamentary group, and that APPG instructed us to help it to collate testimony in a call for evidence about the FCA. And we've seen about 170 pieces of evidence so far, and it's absolutely damning. So there is all of this evidence here, 3 groups of it, really proving that there is a problem with the FCA. Something needs to be done. Even better, you know, the stars were aligned. There is a piece of legislation currently going through Parliament called the Financial Services and Markets Bill. It's a once-in-a-generation opportunity to reset UK financial services regulation. It's brought about by Brexit. We need to onshore oversight of our financial regulation to the UK, but we can use it to deal with other things as well. It should pass into law by late spring of next year. There are opportunities, as with any legislation, to amend it, to introduce new rights and protections, and to focus on righting acknowledged historical wrongs and anomalies. And that's what we're going to try and do. We need your help. So I'm going to talk you through 3 amendments that we're asking politicians to introduce to this piece of legislation. The first can be summarised in this sentence: if you, meaning regulators, screw up, you should pay up. The FCA has enjoyed immunity from civil liability, as I've described, since the FSMA 2000 law came in. A complaints scheme doesn't work. The regulators set the rules, they appoint the complaints commissioner, they set a budget, and they can ignore her findings. Our proposed amendment would mandate that the complaints scheme could cover regulatory failure losses. It would make the Complaints Commission's findings binding on regulators. It would end the civil immunity of the FCA, disapply the Limitation Act for the first 6 years. This is a law that says you can't bring really old claims. So all of the historical claims could be brought for up to 6 years. And that obviously is very valuable for you because you may have a claim against the FCA. Currently, you cannot bring it. And there would be a backstop whereby this is only as a backstop where the FCA is unable or unwilling to secure redress from firms. So it would create a hugely powerful incentive for the FCA to become far more assertive than it has been in the past. And this, therefore, would give Woodford victims not just one, but two routes to redress from the FCA. Currently, in practice, you've got none. The Second Amendment can be summed up in this sentence: what's sauce for the goose is sauce for the gander. Consumers have been campaigning for financial services firms to owe what's called a duty of care ever since FSMA 2000. So this is a law that came into effect in the year 2002. Now, the concept of a duty of care is that it's an obligation on one party, in this case, authorised persons, firms and individuals who are on the FCA register, to avoid causing reasonably foreseeable harm to other people, in this case, consumers as defined in the financial services legislation. So that would create an obligation to treat people better than they may be being treated at the moment. Crucially, it applies even where there isn't a contractual relationship between the two. So, for example, one of the defences that Link or Northern Trust or any of these people might bring is, actually, there's not a contractual relationship between us and these consumers. Well, there certainly is a duty of care. There would be under this law. Parliament would oblige the FCA Parliament last year, I should say, obliged the FCA to consult and bring forward rules about a duty of care. The FCA didn't like this, so it didn't do it. It instead consulted on and brought forward rules on something called the consumer duty. It's a different thing entirely. It has many exemptions, and there is no right of private action or private right of action. So if you've been wronged by a financial services firm because of this consumer duty, you don't have a right to sue it, whereas you would under a duty of care. There's a proposed amendment which we'd summarise as a statutory duty of care owed by authorised persons to consumers. Very simple thing. The Third Amendment can be summarised by this sentence: sunlight is the best disinfectant. The FCA is currently answerable to 3 industry panels and only 1 consumer one. The consumer one is a patsy organisation. The FCA chooses the people that are on it, and it's not allowed to criticise the FCA without its permission. The Financial Services Markets Bill as drafted would change the industry panels to 5, and therefore, or maybe even 6, to just 1 consumer one. So things will get worse. The consumer panel, as I say, is not much good. The FCA's operational objectives, however, have to do with consumers, consumer protection, making sure there's competition, ensuring there's market integrity. And yet our voices as consumers are seldom heard in the governance of the FCA. So we are proposing the creation of a consumer-led oversight body as in Australia, and it's much needed. Australians have got one working there. So our proposed amendment is to introduce a statutory Financial Regulators Supervision Council, FRSC. Its role would be, for example, hiring and firing. It would jointly with the Treasury appoint the FCA's chair and chief executive. Currently, the Treasury does this. It would on its own appoint 2 FCA non-executive directors. They were always intended to be consumer representatives. They were appointed by the Consumer Council, but that was abolished. Now it's the Business Department. They would appoint the directors of the Financial Ombudsman Service and the members and chair of the Consumer Panel. These were all appointed by the FCA. The conflicts of interest there. It would also appoint the Complaints Commissioner, who is appointed by all of the regulators together, but in reality the FCA, because the complaints are all about the FCA. It would carry out an annual review of the FCA and of the regulatory regime. Nobody's doing that currently. It would periodically carry out a review of how the FCA treats whistleblowers and their evidence. I wouldn't mind betting that there were whistleblowers in the Woodford case. I have no evidence, but I bet you that there were, and I bet you that they were ignored. And the third thing is they would commission and oversee independent reviews following regulatory failures. Currently, the FCA does that. In one case, it did it, and then 6 months later, after publication, it actually engaged the guy as a consultant. There's an obvious conflict of interest. It would oversee the complaint scheme rules, budgets, and payments, which at the moment the FCA does or nobody does. So if you agree with these proposed changes to the law, which I hope you would see, if they'd been in place before, maybe Woodford wouldn't have happened. And certainly if they were in place now, you would have a route to financial redress, which has currently been denied to you. If you agree with these things, first thing I'd say is please join the Woodford campaign group on Facebook. And just put a link in the chat. There's a link in my presentation, which I'll upload. It's really important because it's an opportunity to share information, agree a campaigning strategy, and to lobby politicians and others. If you know any other investors that are not in this presentation, please get them to join too. Honestly, the more the merrier. Write to your MP, We have already drafted letters following the Panorama episode that I mentioned earlier. There are 3 versions, one for Blackmore investors and one for other campaigners and stakeholders. You can ignore those. But the third is the one that matters, victims of other regulatory failure cases. That's the one you need to use. We've provided templates and very clear instructions, and we will upload them to the chat and probably email you about them afterwards as well. So really our key messages are, please support our amendments to the Financial Services Markets Bill. They're your best chance of redress and of fixing things for the future. Draft letters are available on the link above, and please let us know what response you get from your MP. So that's me done. I'm going to stop sharing now and hand back to Andy.
Mark, thank you very much indeed. Once again, a very, very informative and remarkably clear explanation and account of what's going on. Thank you very much indeed, Mark. I'm sure everybody would be very happy to join me in showing appreciation for your continued efforts. Thank you very, very much indeed. Thanks all. Thank you. What I propose we do is as follows. We'll jump back to Meriel, give Meriel a chance to deal with the questions that were put into the chat whilst Meriel was speaking. Mark, there's also 1 or 2 for you. So after Meriel, we'll jump back to you, Mark, and then we'll go to Daniel after that. So I hope that's all okay. So once again, Mark, thank you very much. Meriel, could you please take yourself off mute and as succinctly as you can, if possible, get your way through all those questions that were put in the chat. Thank you.
Yeah, of course. Just to say, if I'm, we work very closely with Harcus Parker. So Dan, if there's anything you want to jump in on a lot of these questions, I'm sure you're as capable of answering as I am. So feel free to chip in. But also, Andy, there's a lot of questions. So do stop us if we're taking too long, and if anybody wants to follow up, you've got the details of Lee Day's email address. If you copy your question over, we will try and follow up and help with any questions that you have. So I just wanted to, before going into questions, just reflect a bit on what Mark said about the need for an improvement in consumer rights, which I think is really, really right and really important. And the Financial Services and Markets Bill is, as Mark said, an opportunity for correcting some of the sort of inadequacies in the current regulation, but also to sound a note of caution that it is, I think this government is looking at deregulation rather than increasing regulation, and it's really important that there are sort of voices like Transparency Task Force calling for improvements in protections for consumers and investors, and that is not necessarily where things are headed unless more is done. So just to echo some of those calls, and then going to the questions, I'm just going to rattle through a few of these if I can. I saw a couple of questions about deadlines. At the moment, we expect the court will set a deadline for people signing up, and we expect that will be around mid next year, but we don't know yet. It's for the court to decide, and that will happen following this hearing in December. But I should also make you aware, or make individuals that aware, that the allegations that we're setting out in the claim that Lee Day and Harcus Parker are bringing are made on the basis that Link was failing in its duties and was breaching its duties to investors from around early to mid 2017. The Mark mentioned the rules around limitation. There is generally a 6-year rule. So for anybody who invested before early to mid 2017, we're looking at early to mid 2023 as a key date for you to have your claims issued at court if you want to ensure you can claim for the maximum amount possible. So that is the kind of, there's the deadline for signing up, but there's also the deadline for maximizing your claim, and those are 2 different things and both important to be aware of. Another question I saw was, will there be compensation only for those in the claim, and how does it fit for, what about people sitting outside the claim? So I do just want to make clear that any compensation that we get through the court process and through what Harcus Parker and Lee Day are doing will only be for people who've signed up to the litigation, and it won't be for others. And there were a couple of questions about things like, can I claim if I invested via a SIP? Yes, but if you've got any if you want us to have a look at any specifics of your investment, is it eligible, then please do contact us. I've got a sort of long list of questions, but I'm conscious of the risk of talking too quickly and also not letting Dan have anything to say. So Dan, were there any questions that you wanted to pick up on?
Well, I thought helpful if I keep back the FCA points.
Mhm.
And really what I'd intended to do, and like you, I'm conscious of time, was to give a bit of an overview of things that have happened in the past that we can perhaps draw some lessons from, and then very quickly talk about where we are now and how it fits together with the claim. I think from obviously the conversations we've had before, that we very much see it the same way in terms of the fact that while there are helpful things arising from the FCA investigation, it's very difficult to sit back and wait for them to make their move, and it's important that we forge on while their investigation is ongoing.
Yeah, absolutely. Okay, in that case, I'll just carry on going through a couple of questions, but as I say, Andy, do stop me. So there were quite a few questions around the FCA has mentioned 306 million. Is that enough? And also Link's ability to pay. In terms of Link's ability to pay, I think we've looked at this quite closely. There is a question around Link's financial position, and that has been highlighted by the FCA's recent announcement. Link, the UK entity, the entity that is the defendant in these claims, is a profitable business in the UK. They manage hundreds of funds. They have a lot of assets under management. So we hope that there is an incentive for its group to keep it going. And so there is potential for its group to step in and help fund a settlement or help fund compensation. So that's one avenue if Link can't pay adequate redress. There's also been the mention of insurance. Unfortunately, we don't know the level of insurance that Link has, but we do understand from the FCA's announcement that there is some insurance. And as a couple of people have picked up on, and as Mark mentioned, there is the route of the Financial Services Compensation Scheme. So Mark mentioned that in the context of if there's a complaint to the FOS or if the FCA sets up redress and then that can't be paid. The way the FSCS works is that it has the potential to pay out compensation to individuals if you're in a protected class and circumstances, if you're sort of eligible for a claim, provided that there's a financial services firm which has defaulted on a civil liability. So our view is that individuals claiming through the litigation, if Link defaults, we will be looking to the FSCS, and we would help, Lido would help our clients make a claim from the FSCS if it came to that. So in essence, we hope there will be enough. We're looking very closely at Link's finances, at what the FCA is saying about Link's ability to pay, what it's saying about insurance, what Link is saying about its ability to pay. We acknowledge that Link is not in perhaps the strong financial position that we hope it would be, but there are avenues to compensation out there. Another question that I saw asked was, how do Lee Day and Harper's Parker work together? And somebody wanted clarity about how that works. So I mentioned that we are working together on a group litigation order and that we're working together on generic pleadings. So that is essentially, that's the extent of our collaboration. We work together on arguing the common, the facts and the legal arguments which are common to all of the claimants. We would work with barristers together. We would work with, when it comes to it, we may work with experts together, and we will deal with the things which are common to all individuals together. But what we would do individually is, if you instruct Lee Day would review your documents, check that you are eligible for the claim, have any correspondence with you, and then issue your claim at court. And then if you would be eligible for the AT protection that Lee Day has, and then the same goes for Harper's Parker. So, and it also affects which law firms' fees you pay and how those are structured. So it's just really important to understand before you instruct any firm what exactly you're agreeing to and who you're going to have the relationship with. In terms of, what else was there? A couple of people have asked whether there's anybody looking at a Hargreaves claim. There are sort of murmurings out there of a Hargreaves claim, but nothing has been issued, and we don't kind of know exactly whether that's going to be going ahead or what's going to be happening. We have offered to the other firms that are looking at those claims, if they're looking at Link as well, to join in with the approach that we are taking, and we remain very open to sort of the potential for cooperating, but that is not where those claims are at the moment. I hope I've covered quite a lot of the questions. Was there anything, if there's anything anybody else had a burning desire to be answered, perhaps you could wave a hand, or...
Meryl, that's been very helpful indeed. You've covered a great deal there. Thank you very much indeed, Meryl. Thanks again. What I propose we do now, folks, is we'll jump back to Mark Bishop to deal with the 1 or 2 questions that were in the chat for him. Also, I think Mark's got 1 or 2 questions for yourself as well, Meryl, that you might want to respond to either now or later. So, Mark, let's just go back to you first of all. Then after this sort of exchange of thoughts, we'll go to Daniel, and then we'll open things right up. We were supposed to finish at about 1:30. I'm happy to let things run on for another 10 or 15 minutes more. If people want to continue the conversation, that's fine by me, okay? So Mark Bishop, back to you. Thank you.
Okay, so I think that the only question I particularly saw that was for me was, is there a deadline for complaining to the Financial Ombudsman Service? And the answer is there is not a deadline for complaining to a firm, so far as I'm aware. But once you've complained to a firm and you've got back what's called its decision letter, so basically its response to your complaint, which it should do within 8 weeks, but often they try and stretch that. Once you've got that letter back, that starts a 6-month countdown. Unless there is a good reason, you have to then escalate it to the FOS within 6 months. So if anybody here has made a complaint to any of these firms involved, and you haven't yet escalated it to the FOS, then get your skates on. But if you haven't made a complaint to one of the firms, then I would personally, maybe that the lawyers in this call would disagree with me, but I would personally not put in my complaint right now, because if I did, then I might get my response. That would then trigger me having to go to the FOS, and I'd prefer to wait to do that until I've got all of the information that might come out in the future, and we don't know what that will be. The questions that I really had for Meryl particularly, I think the most important one is to really to clarify where the interaction is between these 3 things. One is your litigation, the other is the enforcement actions of the FCA, and the third is the view of the FSCS. So, for example, if people receive some money as a result of the FCA enforcement action, and I think there may well be a negotiated settlement, certainly the way they tend to go, presumably that means that it's still got claims for the balance shortfall, as long as there is a shortfall.
If I can, just say I think this sort of is the last remaining crumb of what I was intending to address in my talk. So happy to cover that off if that's okay.
Okay, so what if I maybe just say, kind of set out what I think the issues are about this kind of tripod, and then perhaps if you could cover those. So the first one is what happens after some redress has been paid. One of the things the FCA has a habit of doing, if it negotiates redress that is really only partial compensation, is it will pretend that it's got you full redress when it hasn't, because it wants to look like it's done a good job, it wants to fool the politicians. So there may be a statement that says these people have been put back in the position they would have been in had they not invested. We may believe that's untrue. So that's the first thing. The second thing is, if there is an enforced or imposed restitution order that exceeds the ability of Link Fund Solutions Limited to pay, and it's put into an insolvency process, goes into a default, then the money is paid out by the FSCS. Or indeed, if this same thing happens in respect to Woodford Investment Management, which got no money, are the fees payable to the lawyers even where the money is coming from the FSCS? And the third thing is, in respect of the FSCS, have you been having conversations with them about their attitude? Because it doesn't always follow that the FCS will stand behind, for example, a decision of the FOS. If it won't stand behind the decision of the FOS, will it stand behind the decision of the court? For example, it may be that it would say, well, yes, this court has decided that these people should be compensated, but actually the firm could and should have appealed that decision. It might have got to a different position. And also, what will be the attitude of the FOS and perhaps also of the FSCS toward the ongoing enforcement investigation? Is it the case that the enforcement matters might have to be concluded first? Because of course we know that if Link contests the restitution order, then we could be 3 years away from a decision, because it'll go through the RCD and then yeah, is it RCD or RCO? I mean, anyway, those people, RDC, it go through the RDC, then the upper tribunal, and all that stuff could take a few years. And also, we haven't even got to a hint of an enforcement position in respect of any of the other firms, particularly Woodford Investment Management.
Yes, obviously there's quite a bit to unpack there. Andy, I wonder if the thing to do is for me to launch into my wider talk, because that really is the spine of it. I'm conscious that obviously it's 20 past 1 now, and you've had a captivated audience for some time, so I don't want to take up too much of people's afternoons at this point. What I'd like to start by setting out is what I'm intending to do is offer a bit of a case study of what's happened in the past and how that might give us a hint as to what will happen. I'll very briefly, in light of what we've heard so far, talk about where we are now and what the FCA has done and what it means. I think Mark and others have done an excellent job of covering that topic, so I don't propose to say as much about that as I might have otherwise. And then, perhaps most importantly, I'll offer some views as to what we think will happen moving forward and how all of this fits together, which really I think should answer Mark's questions. But in the event that there is more to be discussed there, and I suspect there might be, I would hope that would be a good point at which to have a wider conversation if anyone has the energy for it. So starting with who I am and who we are very quickly. Harkers Parker was founded in 2019, but it was a spin-off from a firm called Harkers Sinclair, and specifically the litigation department of that. What we've been doing for the past 20 years or so is claims exactly of this sort, by which I mean financial actions which often involve large groups of shareholders. For example, we launched the first group claim for financial services related to a film scheme over 20 years ago, and that work ultimately led us towards the Arch Crew claim. And that's the case study I'd like to discuss, which you heard mentioned earlier today on this talk. And I think it'll be quite obvious why I think Arch is relevant as I go. That claim was against Capita Financial Managers. That's an authorised corporate director, and ultimately it was bought by the Link Group and became Link Fund Solutions. At the time we brought the Arch Crew claim, the key people at Capita Financial Managers were Chris Addenbrooke and Carl Middle, who are in fact still the key players at Link. Chris Addenbrooke has recently resigned. Carl is now the man in charge. So we really are talking about the same people. I won't bore you too much with the details of that case, but essentially it involved a failure to supervise a rogue investment manager who made some very questionable decisions as to where the money should be. And there were a number of issues around investments that were made on what was then the Channel Islands Stock Exchange, which offered an impression of liquidity, which ultimately didn't prove to be accurate and led to that fund's demise. Note that the Channel Islands Stock Exchange subsequently became the International Stock Exchange. Can't imagine why they rebranded shortly after Arch Crew. And it is indeed the International Stock Exchange which features heavily in the Woodford narrative, and where many of his more illiquid choices ended up being listed at the last moment. So there are serious echoes there. And naturally you'll be wondering, well, what happened in Arch in the end? Well, one thing is that the FSA, as it then was, stepped in and imposed a scheme. It's estimated that there are about 160, it was a much smaller investment vehicle than Woodford, which is basically true of any fund these days. But there were about £160 million of loss in the funds. keep that figure in mind, because what the FSA did was impose a £32 million scheme on captive financial managers. And they said, well, others are going to have to contribute as well. So the total we're going to see you all paid is 54 million. So you're looking at, crudely, about a third of the estimated losses at that time. So that scheme was out there and people were able to take part in that. Notably, what was said at the time was, you can have this money, but you do so waiving any right to bring any further claims. This is you accepting that this is full recompense for what has happened, and essentially acting as a block to people who wanted to join the claim. Obviously, we disputed that, and what we set out to do was to claim the difference for everybody who signed up. So rather than just getting that third, you would see more like 100%. Unfortunately, one of the parts of the story I have to be quite careful about is how it ends, because ultimately there was a settlement. I'm allowed to tell you that much, and there was an element of satisfaction, shall we say, on both sides. So what you have there is Capita, which becomes Link, doing a very, very light touch job of supervising an investment manager who's making some quite dubious decisions. Ultimately, the FCA coming in, imposing a fine and a scheme, and investors being left with the difficult decision of deciding whether or not to continue to fight it out, or to take a pretty low offer and cut their losses there. And the narrative being that this is a good deal for everybody involved, and everyone has fulfilled their function. Just so happens to be that all of that, which took place about 10 years ago now, was when I joined what was then Harkers Sinclair, and that was the first case that I worked on at that firm. So you can imagine that when we fast forward to 2019, and I see Carl Middle and Chris Addenbrook at what's now Link Fund Solutions, involved in a failed fund, which involves investments on the Guernsey Stock Exchange, and serious questions as to liquidity management, alarm bells ring, and I think this all feels like quite familiar territory. And so we took an immediate interest in the project. We sent a letter of claim back in, I think, early 2020. One question that you can imagine we get asked a lot, particularly in September 2022, is why has all of this taken so long? What have you been doing, basically? And one thing I think that's crucial to note here is that we're in the unfortunate position in this country that in order for anyone to see justice in these sorts of cases, they have to actively opt in. And there is a cost risk upfront to litigation that has to be mitigated. And the way that you do that is by going to a third party and seeking their investment essentially in the case. They sit behind the law firm and they rely on you, A, achieving a successful outcome, and B, signing up a large enough group of people that they will get their money back and see a healthy return. And you can imagine that there's quite a lot of money involved in all of that, especially for the insurance that's necessary to keep everybody protected. And so that unfortunately all takes rather a long time to get. And then when you have multiple firms all progressing similar actions as we do here, it's very important that they coordinate as much as they can and all get onto the same page. And as I hope you will have gathered from what you've heard so far, we've enjoyed a very productive relationship with Lee Day in doing that and bringing a unified front that we collectively feel puts the case at its strongest. So where are we now? You will have heard throughout today and in the news that there is this proposal of a £306 million redress scheme on top of a £50 million fine. The FCA are making noises that they're at the point of making some form of a decision. And we wonder where that leaves us. I think it's worth very, very quickly talking about the context in which they have finally revealed those facts. And a lot of that is driven by a potential acquisition of the wider Link Group. So that isn't the company that we are suing and the company that the FCA is directly investigating, but the parent, which is an Australian listed entity. And that Australian entity was being bought by a very large Canadian tech company. And so what was necessary was for the Australian entity to get authority, both from the FCA for the subsidiaries that it has in this country, and from the Australian competition authorities to say that this deal could go ahead. So suddenly the FCA is put in an awkward position that it's been investigating all of this for some time, but now it's got the prospect of a completely new third party coming in, who obviously had no, should we say, culpability or involvement in the events that relate to Woodford. And what are they going to do about all of it if when the time comes and something needs to be paid, what would their position be? So the FCA has to say something, and it's in that context that they come out and say, well, we'll approve you and we'll let this transaction go ahead, but only if you'll commit to meeting any shortfall in the redress scheme that we think we're going to impose. And at this point, we say that's going to be up to £306 million. And so at that point, we sort of have a very strong hint of where the story is going with the FCA. But it was unexpected that it would only be a week or so later that the FCA announced essentially that they've concluded their investigation and they've sent a draft warning notice to Link. That's a significant point because that's the stage at which essentially they're saying this is what we think we're going to decide. Do you want to just throw the towel in now and give us some money? And that there is a significant question there for Link because in Arch, the fine which would have been imposed would have been reduced by 30% if they had paid the money straight away. As it is, they agreed to put in a scheme which exceeded the fine. And so for that reason, the FCA said, well, we're not, or the FSA then said, we're not going to fine you. We'll make do with the scheme that you're putting in place. So where does that leave us looking forward? What do we think is going to happen? Well, I think Mark has done it, and Mary have done a good job of explaining that the timings of the various FCA next steps are difficult to say. We know that Link now has another week to either settle with the FCA or provoke the next stage in the process, which, if their public announcements are to be believed, may well be a challenge to the decision, which ultimately is the first level of an appeal process. And it's difficult to say how long that appeal process will take because, of course, we don't know precisely what the FCA has said, and we don't know what the specifics of the appeal would be. But it is easy to imagine that could all take some time. We do have the assistance of knowing that despite some concern that the FCA might want to say, we've always been looking at this, and while it's all rather regrettable, we don't think anyone was at fault. It's clear the FCA isn't going to go that way. And I think, as Mark picked up on, there are serious questions about all of the entities that are involved in this investigation. Understandably, a lot of people focus on Neil Woodford personally and Woodford Investment Management, and their feeling is, well, why is it that this company I've never heard of called Link is getting all of this abuse, and he appears to be sailing off into the sunset without any real retribution. One way of looking at that is the way that these funds are structured is that it's necessary to have someone who makes decisions about where the investments should be made, and essentially tries to extract as much value from unit holders for unit holders as he can. But it's important that there is someone there to regulate that and to keep a close eye on all the decisions that are being made, and to ensure that they're all within the boundaries of the mandate and the FCA rules on how funds are to be managed. And that is Link. So what you're seeing here is a failure to keep something on the rails, and that responsibility always resides with Link. Link could in fact have taken all the investment management decisions themselves, but they chose to delegate that role to Woodford. There's something artificial in all of that, because how these things work is that the investment manager goes and says to someone, will you be my referee, and you'll be paid to make sure I behave. And often that remuneration obviously is linked to how that fund will perform. So that leaves some structural difficulties that ultimately means that everybody involved in the structure knows that ultimately the buck stops with the ACD, in this case Link. And I wouldn't feel too sorry for them, because that's what they're remunerated for. Their job is to make sure that this all doesn't happen, and when it does, naturally they're the first place that you go to. I've seen many sensible questions that really revolve around, well, are they good for the money at this point? This is obviously a huge fund that has failed so catastrophically that it requires an enormous amount of money to set people right on where they are. As Muriel has said, 306 million obviously does not represent all of the losses that people have suffered. And Mark asks the sensible question, well, what about the shortfall? Pausing just for a moment there, it's worth noting the timing of all of this. We really can't say when that 306 million is going to happen. And it's obviously impossible, therefore, to say what would come first, the end of our case, very much hopefully on a positive basis, or that redress payment. And so it's true that you wouldn't be able to receive the same money twice, but one version of events could certainly be that you receive some compensation through the FCA mandated scheme, and that leaves you with a surplus claim which continues through the courts. But the specifics of that will obviously depend on the timing, the nature of the offer. And we certainly will be liaising and have begun conversations with the FCA and with the FSCS and all the related parties as to how that works. Just digressing slightly, somebody raised a sensible question of, well, how does the takeover transaction affect all of this? Worth saying that transaction, as far as we know, is now off the table. We had an announcement just over the weekend that Link have cut off that conversation, essentially because the price that was being offered in order to account for this major potential liability just wasn't the money that they were looking for. So it appears that we're back to where we were with Link having to stand this on their own. I wanted finally just to touch on where the money might come from if Link were unable to pay. We know that they have insurance, but as Mark says, we don't know how much it is. I don't think it's helpful for me to speculate on what that amount might be, but we know from the FCA that they feel it's less than £306 million. So the insurance is one part of it. I think it's worth noting that the Link Group has several entities in the UK, all of which are regulated by the FCA. It would obviously be utterly disastrous for the wider Link Group if they were to say to a regulator and to the FCA, we're not going to do as you tell us to do. We accept that you found us to be liable for this amount of money, but we're not going to pay it. And we know from the transaction that the speculated value of those entities is closer to £900 million. So that all goes up in smoke somewhat if the FCA loses confidence in you and says, well, we're not going to authorise you to continue to trade anymore. So it really is the highest of stakes for Link as well. And they'll be mindful of that in whatever it is they choose to do. I think it's important as well to bear in mind, and I'm conscious of time, so I won't go into too much detail on this, that behind every ACD, there is a depository, in this case, Northern Trust, that again, Mark touched on. Although I should say it's a different Northern Trust entity to the one he listed. And they have a supervisory role over Link. What we saw in Arch and what you often see in cases of this sort is that the ACD will say, well, we did nothing wrong, but if somebody thinks otherwise, then it's only right that they should be looking at the depository as well, because if we fail to keep within the grounds, Andy, just to answer your question, is Northern Trust Group SE. I'll just make sure I get that name exactly right. Northern Trust Global Services SE, which is a Luxembourg company. I'll also pop that in the chat just so everybody's got that. So we would expect that although we don't have a straightforward direct route to Northern Trust at this point, you could well imagine that they will be brought into this through Link. And obviously Northern Trust, from a financial standpoint, are a significantly bigger player than Link are. But even so, those are ways in which they can be paid. But failing all of that, you do find yourself looking at the FSCS. Again, I'm conscious of time, so what I'll say quickly is that let's assume the worst case scenario, that everyone who could pay for this goes bust and doesn't meet any award. At that point, what people would have is a claim that has been made good against a financial institution who's unable to pay. And so the vast majority of the sorts of investors that Woodford attracted would be able to go to the FSCS and say, hello, they've gone bust, so we need the state to pay. And as has been mentioned, there's an £85,000 cap on that. But that is a route that I think a great many investors would be able to take should it come to it. In some ways, rather unsatisfactory to see the people who many people would say were at fault here able to leave it to someone else to pay, but at the same time, some measure of comfort for investors that there is money at the end of the rainbow, one way or the other. Very happy to take questions, but again, conscious that we've run over time, so I will cut it there.
Daniel, that's been a particularly interesting session. Thank you very much. That really was very, very informative indeed. Thank you also, of course, to Muriel and to Mark and to Neil. I hope everybody's got a lot out of this. I've certainly had various gaps filled for me in terms of my knowledge and understanding. Personally, I don't have another Zoom meeting to get to until 2 o'clock. So if anybody else wants to carry on chatting away, we're happy to do that. Of course, if Daniel and or Muriel, Neil, and Mark need to wrap up and go, that's fine. But please stay if you can and if you want to. So allow me, if I may, just to invite anybody that wants to come in with a point verbally as opposed to using the chat to do so. I'll change my view to gallery view. Just wave at me if you want to come in with something now. Otherwise, we'll gradually go into kind of closing up the session mode. Mr. Mark Bishop, then we'll go to Mark Rogers. So Mark Bishop, then Mark Rogers. Thanks, guys. Cheers.
So firstly, Daniel, thank you for a very clear and I think really informative presentation, and particularly for rehashing the Arch Crew story, which is a fascinating one. I think more people should know it. Talk about history repeating itself. I also think a point I would make about Woodford and Woodford Investment Management, it may be that it's seen as a bad litigation risk simply because it's got no money. But I think it's a very good target for FCA enforcement because there is very clear causation there and wrongdoing. And if the FCA were to issue a significant order against that firm, it would presumably then go to the FSCS and be paid out. And I would hope that's the strategy. And I think if it's not the strategy, I think it's also a good target for consumer complaints, which would then go to the FOS and then to the FSCS. So I personally don't think that that firm will end up, getting away with it. And of course, if it were to go into an insolvency process, an insolvency practitioner might look at some of the payments that have been made out of the firm to the shareholders and might seek to reverse some of them as well. Who knows?
Thank you, Mark. And it goes from Mark Bishop to Mark Rogers. Mark.
Yeah, thanks very much for the presentation. It's very, very helpful. Thank you. It's actually a question that's come up on the chat, which is if the litigation fails or that we don't get any compensation through litigation, and payment comes through the FSCS, would the law firms be taking their 30% fee out of that? Could we just have some clarity over that if that situation arises?
Sure. I should say, I think it's worth giving an opening disclaimer here that I'm afraid I'm probably going to give you a slightly lawyerly answer, but I'll try my best to be as fair and transparent as I can. When you posed the question there, you expressly said if the litigation failed, and that's an important point here, because what lawyers are able to be paid out of is what is defined as claim proceeds. I can't speak to the Lead A documents and exactly how they define that, but keeping it pretty simple, the idea is if money flows from the claim, then that is something we can be paid for. So to answer your specific question directly, if the litigation were to fail, so if we were to withdraw the case or a court were to find against us, but then there was an FSCS scheme, I think it would be very difficult for us to argue that ought to be something we should be paid out of.
A very good question and a very clear answer. Thanks again, Daniel. We're going to go to Duncan. Please, Duncan, take yourself off mute and turn on your camera. You've done that. Thank you. Perfect.
Yeah. Thanks to the presenters. That's very. It's the first time I've attended anything like this. That's really interesting. I've got a question for either Daniel or Meryl, probably Daniel, but forgive me if it's already been answered in another way or it's a naive question. But is there a someone's put, is there a downside of any claimant joining either of these claims? And I'm not a lawyer, clearly. Is there a possibility that if litigation turns out in exactly the wrong way, that the defendants could come back to the claimants with, say, a case of damages to be costs to be awarded, for instance? I know that might seem very unlikely given everything we've talked about, but is it a theoretical possibility, I suppose, is my question. And quite a few people seem to have asked something along those lines. Is there a chance that we've lost money and then
good money after bad?
Yeah.
No, I completely understand the question.
Not even that, we lose more.
Well, yes, indeed. I think the fairest way to answer that is there is a theoretical possibility. Naturally, our job is to make that risk as theoretical and unlikely to occur as possible. So I'll just talk briefly about how that works. In cases of this sort, it's absolutely vital that the firm you instruct has good and proper insurance in place, and that insurance covers your liability if you were to lose a case. The standard position in litigation in this country is that if you sue someone and they successfully defend the claim, then they ought to be able to recover at least some of the legal expenses they've incurred defending that case from you as the party who brought it. In reality, in a case of this sort, you can imagine you've got so many individual consumers that going after all those individual people is a nightmare in every respect, administratively, from a PR point of view, and in terms of actual recovery, the cost of doing so. And so what will happen is the firm ought to be able to tell you, as we can, and as I know Lee Day can, that we have insurance in place to cover that. What we also do is we ask insurers and pay for insurance to issue what is essentially a promise that, come what may, they will meet the award. So even in a sort of disaster scenario where there was a fault on behalf of the claimants or the lawyers, such as myself, even then the insurers would not be able to wriggle out of paying. They would still have to pay up. It's just that they would immediately darken our door and come after someone if they felt they could. But you have that additional protection there. Even if all of that were to fail, what we see is that defendants will say, well, hang on, behind all of this is an entity with very deep pockets that's funding it. And if we're not being paid by the insurers, then that funder should have to pay us. And that, in fact, is what provoked those endorsements and those promises that I spoke about just a moment ago. So yes, in theory, it's only fair to say there is a theoretical risk, but my honest view is that the likelihood of that ever reaching a claimant in a case of this sort is very, very low, because from a commercial standpoint, you'd go after the insurers, very difficult for them to wriggle out of it. You'd go after the funders next, again, difficulties there. Would you then bother going after 1 million people for a small share of the larger amount? I'm not so sure you would. So that's my take on it.
And I just echo that as well from Lee Day's perspective. That's the same approach we take.
Meryl, thank you. Daniel, thank you. Does anybody else have anything that itching to say before we wrap the session up? I noticed Jack Gilbert, for those of you that haven't watched it yet, watch the Panorama programme. I've just put a link into the chat. It's had about 40,000 views on YouTube. Amazing. Plus, of course, whatever free amount of views it's had on BBC. So Jack Gilbert's a New Bond advisor and was in the Panorama programme about Blackmore Bond. Meryl and Daniel, so Jack's question is, yes, but what if the claim was successful, but Link Fund Solutions still collapsed on the FSCS? Jack, do you want to elaborate on why that's such an interesting question? And perhaps Meryl and Daniel will be happy to respond to it.
Thanks, Santi. Thanks for the intro as well. No, I mean, I just was slightly confused by your answer, Daniel. You said, I think that if your claim was unsuccessful, then obviously you wouldn't be paid your fees. But what if your claim was successful, but at that point, Link Fund Solutions then fell on the FSCS? Would you still then claim your lawyer's fees from their compensation?
I follow, and it's a sensible question because it's the obvious element of it that hasn't been hit head on. I think the short answer is probably yes, in that you would still be recovering the fee through the case, if you see what I mean. And it's important to stress here that what we wouldn't be talking about in this context is only that 306 million, or your share of that 306 million. We would be claiming all of your loss. And the way that, particularly, I know in our case, claim proceeds is defined, and I would suspect it would be similar for the other firms, would be if you're paid by someone for this claim, then we're entitled to our share of making that happen. So in the event that it was the claim money that you were receiving, albeit that you got it through the FSCS rather than directly from Link, yes, I'd imagine. And that would also be true if, as would be likely, you saw the liquidators stepping into Link's shoes because they'd gone bust. So that's a long-winded way of saying yes, I think so.
Yeah, and just to add to that, so say for instance you went tomorrow to the FSCS and said, I want compensation because something happened with this fund, they would turn around and say to you, no, you've not got a proven civil liability against Link. We're not going to pay you any money. So any compensation through that route would be a kind of direct consequence of being part of the claim and having a judgment in your favour. And then it's part of our terms that we we would sort of help you with that process, the final step of getting the compensation. So we wouldn't get you to sort of 2 steps away from compensation and then stop. We would take you all the way, and then we would charge our fees at the end when we get compensation.
Thanks, Jack, Daniel and Meryl. I'm going to be bringing the session to a close by making a strong suggestion to everybody. I'm going to share my screen to help me bring this point to life. Peter Blythe put a question in the chat to the lawyers. Obviously, I'm no lawyer. About, you know, what's the chance of success? In my personal opinion, the more political pressure there is to make the Financial Conduct Authority do a decent job by consumers in terms of protecting them from harm and, frankly, organising for them to get redress and compensation if they are harmed, the more political pressure there is, the better it's going to be. We've learned as a campaign organisation that one of the most effective things you can do to build political pressure is to organise and mobilise constituents around the country writing to their MPs. So this is the webpage that Mark Bishop was speaking about earlier. As you can see, its title is Letters to MPs about Panorama and the Blackmore Bond Scandal. The important bit here is option 2. So option 2 is the letter to be sent by somebody who's a victim of other investment scams, i.e. not Blackmore Bond. Therefore, option 2 is the one that relates to people who have lost money as a consequence of Woodford. It's very, very simple and remarkably potent, okay? So all you do is you go to this web page, you click download here, you fill in the yellow bits, which is really, really, really easy. And there's a very well constructed, in our opinion, Mark Bishop wrote it, so believe me, it's very good, a very well constructed letter to the parliamentarian that sets out how and why there needs to be reforms to support the idea of the FCA being made to do its consumer protection job more effectively than it does now. All the hard work has already been done for you. Please use these letters to good effect. We'll make sure you get the links. There's been over 300 or so letters already sent to parliamentarians. We know we're having an impact, and as Mark Bishop earlier described, the timing is remarkably helpful, because right now we've got the Financial Services and Markets Bill working its way through Parliament. There's a lot going on behind the scenes that we're involved with in terms of interaction with parliamentarians that we don't have time to go into right now. But believe you me, we're doing all we can to promote the 3 reform ideas that Mark spoke about earlier. Number 1, this is in no particular order. Number 1, there really does need to be much greater, much better accountability and scrutiny regarding the FCA. Number 2, its protection from civil liabilities needs to be removed. And number 3, there needs to be a proper full-fat duty of care, not this watered-down consumer duty that's practically useless without a private right of action. And as you probably know, there isn't a private right of action. These are all the sorts of things that parliamentarians can make happen. And we know enough about this game of campaigning to know that the more pressure and the more publicity, the more chance there is of getting the kind of reforms that would be necessary to make the changes that would help people to get more compensation in a more straightforward way. I hope it's been a useful session. I know I personally have picked up a great deal from it, particularly from all the speakers who've spoken today, but also some of the questions that have come in have actually taken the conversation into particularly useful areas. It's just coming up to 2 o'clock. My apologies for mismanaging the time a bit, but there really has been a lot more content than I was anticipating today. I guess that's a good thing. So we'll wrap it up there. Thank you all very, very much indeed. And we'll look to organise another one of these to catch up in however many weeks or months' time, but we will do something. Thank you all. Thank you very much. Cheerio, guys. Bye-bye. Thanks, Daniel. Thanks, Meryl. Thanks, Neil. Thanks, Mark.
Yeah, thanks, Andy. Thanks, everybody.
Cheers, guys. Thank you. Bye-bye. Bye-bye.
Bye-bye.
Bye-bye. Thank you. Well, I do hope you found that video useful and informative in some way. Please do remember, if you haven't already done so, become either a subscription member or make a donation. Both of the links you need are coming up on your screen now. And they're also in the video description. Thanks again. Thank you.